Hello everyone and welcome to today's Mondac webinar in association with KPMG Law, who will provide an in-depth exploration of the current hot topics in employment law. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. Adrian Tuscher heads KPMG Law's Employment and Immigration Practice Group. He advises national and international clients regarding employment, immigration and social security law matters, particularly related to corporate immigration, assignments, hires of executive employees, dismissals, including negotiations of termination agreements, international deployment, staff lease and employment participation programs. Adrian namely has extensive experience in Swiss and cross-border employment law in designing and implementing mobility compliance processes, as well as remuneration and participation plans. Further, Adrian also advises companies on legal tech solutions and the optimization of their legal operations. Gaurav Bhagwanani is a director for KPMG Law and a Swiss employment lawyer who regularly advises national and international clients on all aspects of employment law and related matters, particularly on the drafting of employment and assignment agreements, including restrictive covenants, employee handbooks, policies, termination agreements, drafting and design of bonus and equity-based compensation plans, as well as namely on staff leasing, mass dismissals and work permits. He also assists buyers and sellers with HR due diligences in M&A transactions and the transfer of employees. Finally, Gaurav also supports clients during labour inspections. Now, before I hand over to Adrian and Gaurav to begin today's webinar, a quick housekeeping item. You are able to submit questions for the panel by typing them into the questions pane of the toolbar on the right-hand side of your page. We will endeavour to answer as many of those questions as possible during the Q&A session, but we'll reach out after the webinar for any that we aren't able to get to. It's now my pleasure to hand you over to Adrian and Gaurav to begin. Thank you.
Hey, thanks for having us, Dan, and for the kind introduction. And hi, everyone, and also from KPMG Law in Switzerland, a very warm welcome to this session on hot topics in Swiss employment law. My co-presenter, Gaurav Bhagwanani, and I, we would like to thank you for joining in, obviously taking the time to meet with us today. And we're looking forward to now taking you through, in the next 60 minutes, I think, pretty crispy agenda. So actually, out of the many topics, that have been trending in the Swiss employment law recently, or actually increasingly hitting our tables in our day-to-day work, we just thought we're going to pick 4 that we think could be most relevant for you, or at least topics that you haven't already come across regularly in all the various law firm newsletters that you might have signed up to. So what does that mean? So we're first going to have a look at employer of records and some of the pitfalls that may come with them, in particular from a Swiss legal perspective. Then we're going to delve into the use of AI tools during the recruiting process, and particularly what that could mean from a data protection point of view, before we go into an evergreen, namely terminations during sickness and the related blocking periods, which often lead to confusion. And ultimately then, before opening for questions or answering the questions that you guys may put in the chat, please, we'll look into the granting and terminating of benefits. Now, before I get started, allow me please to commence. First of all, as the title of the session indicates, we're going to focus predominantly on the Swiss legal side of things, bearing in mind, of course, that in international circumstances, there might be other jurisdictions coming into play that could obviously then have an impact on the assessment. And then second, because we have an amazingly diverse, I have to say, audience today, consisting of people with a HR, a finance, a legal, a compliance background. We won't go into the nitty-gritty legal details, but try to be pragmatic. Now, having said this, let me jump straight into the first topic of employer of record, as I already outlined. And the question, a bit provocative one we want to pose is it an efficient solution, or does it come with some legal pitfalls? Now, let's tackle this by asking the question, and next slide, please, and you may click. What are we talking about? What is an EOR? Now, an EOR, or an employer of record, is a professional service provider that, as a business model, hires employees on behalf of a third party that typically, or in almost all cases, is located in another jurisdiction, and then immediately and permanently leases those employees back to that third party, which is the client of the EOR. Now, the use of EOR is a relatively recent appearance in the Swiss market, or actually the rise of AOR. So there have been many AORs finding their way to Switzerland recently and set up their offices here. But it received quite a boost during the pandemic when many Swiss nationals, kind of wanted to return to Switzerland when they were working abroad before in order to be close to their families, or then also some non-Swiss nationals discovered Switzerland as a safe harbor in those critical times. But besides those private drivers for making use of an EOR, there are also valid business reasons that drive more and more companies to make use of an EOR. Click, please. You see some of them listed there. One of the most common ones currently is global sourcing. So, the war of talent has expanded to the world. If you identify talent far away from your headquarters and that talent isn't necessarily willing to move cross borders, you could look into using an AOR to source that person. Then we see a lot of companies who want to enter a new market, or in this case then Switzerland, but not go full steam ahead from the very beginning. So they don't want to build up substance right away. So they decide to go with an EOR first and then see how it goes before they decide to set up an entity and put some substance in it. And maybe another I would like to pick, which is interesting, is that many companies think, and it's not always true, that by working with an EOR, they can avoid certain pain that may come from having a local presence, like legal housekeeping, for example, or corporate housekeeping, then some tax, regulatory or other obligations that they would be subject had they have an own legal entity. But I will get back to what extent this is really doing the trick or not. Then let's have a look, please click at a typical setup of an EOR. So typically the company, so the client of the EOR, determines the employment terms as a normal employer would do, under which the employee then is though hired with the EOR and not that company. That's the specific of the setup. The EOR then handles the employment administration, so Social Security, insurance, tax, whatever comes with the payroll, and so on. And for that purpose, the EOR and the client, so the company, do conclude what we call a service contract, under which then the company undertakes to kind of reimburse, obviously, the EOR for the employment-related costs, particularly salary and any potential additional benefits, in addition to the service fee that the EOR typically asks for, which is quite diverse in the market. Now, and that is kind of then coming to the core of the legal issue. Under this service contract, typically the EOR transfers all the essential employer rights, in particular the instruction rights regarding the day-to-day work, to the company, so its client, which then ultimately means that formally the EOR is the employer, but factually the company, so the client of the EOR, is the employer. Let's move on to the next slide so we get this quickly illustrated. So we see we have an EOR here now in our example in Switzerland. We have a third-party company who wants to employ a source in Switzerland, and for that purpose enter into such a service contract. And you already see in brackets staff leasing agreement, which then triggers some legal considerations I come to in a minute. And the EOR enters into the employment contract with the employees. And you see there the dotted line. There is no, at least not on paper or not in writing, a formal contract between the third-party company and the employees themselves. Please click. And that is just illustrating what everyone does. So you are doing the employee compliance, payroll benefits, and obviously a third-party company determining the salary and instructing the employee and equipping him or her on a day-to-day basis. Now, so far so good, but I already indicated that it comes with some considerations under Swiss employment law, so maybe you can move a slide on, please. And the overarching question is that you have to ask the question whether such a typical EOR setup is considered a staff leasing under Swiss law, namely because Swiss law knows pretty specific regulations in this content, and typically, or essentially, whenever like essential instruction rights are transferred from a company over their employees to another company, then we may look into, or we may have to consider the staff leasing constellation. And the Swiss Federal Supreme Court has kind of concretized this a bit by coming up with the main criteria. So this is about the level of integration of an employee within now the third-party company in our example with an EOR, and that like covers all the aspects: personal integration, organizational, functional, and so on. And then also to what extent the employee is being equipped by tools by the third-party company that help him to perform his work properly. And then last but not least, it's also a question of the liability governance that you apply to the contract. So typically an EOR doesn't want to be held liable for a potential misperformance for an employee. So that is another how can I say, criteria that drives us toward the staff leasing constellation under Swiss law. So you potentially agree with me that looking at this, we may assume that the vast majority of EOR setups do qualify as a staff leasing under Swiss law, which then means that the EOR, in order to carry out that business commercially, is subject to license requirements. So the EOR needs to get or obtain a license from the Swiss State Secretarial of Economic Affairs, that is called SECO here on this slide, in order to legally operate. And yeah, unless you're not doing it commercially, but you see the thresholds are really low, so most reasonably successful EORs do fulfill these criteria and have to get such a license. Now, you cannot just simply get it in a sense that you ask for it and you get it the next day. You have, as an EOR, to fulfill certain requirements, starting with a HR responsible person that can actually guarantee that in this somewhat complicated triangular legal relationship, the employees do not suffer any disadvantage. So there is some requirements applied to this person in terms of qualifications, residency in Switzerland, and authority to sign on behalf of the EOR, because that person would also have to sign the employment agreements with the employees. Then the EOR has to deposit a security of 50 to 150K with a Swiss bank, or then get a corresponding bank guarantee. And that is also quite important from a practical perspective. When you employ or get employees employed by an EOR, you cannot just simply ask the EOR to use your own employment contracts, but they have to actually use those employment contracts that have been approved by the SECO. So there is quite a number of requirements around, again, making sure that the employees are reasonably protected, which basically is about social security, termination, and some protection during sickness and the like. Last but not least, an EOR needs to present proof of accident insurance for its employees. Now, next slide, please. You may wonder why I'm telling you that, because I assume that only very few of you, if at all any, are EORs themselves or working for EORs. But the reason I'm telling this to you is because you, as a potential client of an EOR, need to be aware of the sanctions that come with non-compliance. So you see that here on the top of the slide. If an EOR is in breach or actually does render EOR services without the necessary license, they face a fine of 100,000 per incident, whereas you, as a potential client of an EOR, may also face substantial fines of between 20 to 40K, depending on whether the use of a EOR without a license can be considered deliberate or negligent. In your case, so sorry now for making you a deliberate user potentially of an EOR without a license by telling you that. And then last but not least, without the necessary license, actually the whole contractual setup between you and the EOR may be considered null and void under Swiss law. So there is some risk coming with that, which is basically why we recommend to, ask the EOR for confirmations that they are in compliance with the applicable laws. But we've seen in practice that many of them currently underestimate some local environments in certain countries like Switzerland, and just keep going without really making sure they meet all the requirements. And for that, we recommend you, particularly when it comes to whether the license is there, to check the link that we provide here on the slide, where you can see the publicly announced holders of a license. And you have to make sure that the EOR holds an international staff license and not just a national staff license. And then I've brought two clauses that might be actually found in an employer of records service agreement, so the agreement between the client and the employer of records. The first one says the EOR has the sole right to instruct its employees in the course of the service provision to the third-party company. And that would actually then kind of, create the impression that no staff leasing is present, but the authorities there are not stupid. I mean, if someone's known for advertising employer of records services, and then even if that is put into a contract, they would probably look through that and ask questions around these circumstances how these circumstances are really lived up to, and that wouldn't necessarily help. And the same is true for the second clause, where you see that the contract says that the employer rights are to some extent shared between the EOR and its client, but also that, of course, doesn't help. It's not good enough to get out of the staff leasing license issue. So next slide, please. So yeah, to come back to the initial question, it comes with certain pitfalls. Obviously, it is an interesting setup because it's set up quickly. It does come with very little, if at all, with HR and payroll administration on the end of the client. And obviously no need to set up and run a company in certain jurisdictions where the appetite is currently low. But it comes with certain disadvantages that are not only legal. So you see there is and that has been surveyed with people being employed by EORs, obviously a certain sense of social detachment. So not easy to make an employee far away being employed by an employer of record feel home and integrated in the team. Then, because of the considerations around the staff leaves, you may have some insufficient uncertainties, maybe is the better word, regarding the overall contractual situation, and also the employees may suffer from some ambiguities towards the rest of the firm or the factual employers that are potentially treated differently because it's not easy to align different jurisdictions. And then another pretty valid, or how can I say, worthwhile to quickly speak about a disadvantage is the corporate tax risk. But I'm pretty sure all your tax departments will bring that up at every potential opportunity. So when you, for example, in Switzerland, work with an EOR, you're not kind of safe that the Swiss tax authorities wouldn't consider to set up a potential permanent establishment if the person generates revenues or value in Switzerland. The authorities might look through that and still consider the factual employer, so the client of the EOR being outside of Switzerland, as taxable for corporate purposes in Switzerland. And actually the same is true vice versa for the EOR abroad. So that are considerable risks. But sometimes I see also that they're being a bit taken too seriously by tax departments that then would urge, HR departments to come up with really strange setups using AORs and even sometimes more complicated setups just to avoid the PE, or sometimes then the setup chosen brings more risk than the PE would, or the pain that comes with the PE would. So sometimes HR needs to fight back a bit there in my eyes. Then we have obviously the staff leasing compliance issues that I spoke about. And last but not least, if you're using a Swiss EOR, you need to be aware that it's hardly possible to get a work permit for the EOR, or actually the EOR has to apply for the work permit for the employee to be hired through the Swiss EOR. And if that is a non-EU EFTA national, it's almost impossible to get a Swiss work permit. It's different for EU nationals because they have the free movement of person, but just so that you know. So next slide, please. I just would like to quickly raise your awareness to the opposite case, because that's also something that many people don't know. So we kind of turn the game around and say we have the EOR outside Switzerland and we have a third-party company assigning the EOR outside Switzerland, and the rest of the setup stays the same. Then we actually have the situation that the EOR leases staff into Switzerland, and please click again, and that's generally prohibited under Swiss law. So inbound Switzerland staff leasing generally not allowed. Nevertheless, EORs are offering it. Many EORs are saying they're in compliance with all the laws, again, because they don't know or because they just want to sell. And also there's many Swiss employers making use of that service, even in case, they're aware of the risks. But the reason for that is probably that typically they don't go, the authorities don't proactively go after these cases. There's no real enforcement body. So this typically pops up when the employees then being employed by the employer outside of the EOR outside Switzerland come to Switzerland for a business visit, and then the EOR applies for a work permit. Then the immigration authorities look into the contractual setup, and then it can pop up and be flagged by the authorities. So just be mindful if you contract with an EOR outside Switzerland. Please be sure you at least look very carefully in the liability clauses in the contract with the EOR and try to negotiate the hold harmless clause for the case of non-compliance. The next slide. I won't go into that in detail. That's basically a summary and key takeaways for you to bear in mind when you work with an EOR, be it in Switzerland or outside Switzerland. Meant to be a post-session read for you. And with that, I hand over to Gaurav to elaborate on the topic of AI in the recruiting process.
Excellent. Thank you, Adrian. Next slide, please. And we can jump right into it. So nowadays, there are a lot of recruiting tools out there. And as we are speaking, probably more and more are being developed and emerging as we speak. So meanwhile, all these recruiting tools also have a lot of AI functions in them, and they possess a vast variety of functions which can leverage AI. For example, in creating a job ad itself based on skills and qualifications needed, screening incoming applications and extracting relevant information, for example, matching potential candidates with job ads that are published, and also job positions which are open, and maybe even freelancer which form part of a pool. The phenomena which we have also seen is that even scheduling and employee interaction or candidate interaction can take place. So nowadays, certain tools are able to schedule interviews, schedule meetings, and even chatbot-like answer first questions like how much vacation weeks do I get per year when I would work for you? And that works pretty well. What we have noticed as well, and it's been a phenomenon in the US at times, is that unlike robo-firing, there can also be robo-hiring, which means that an automated process takes place in the decision if somebody gets hired or not, which certain tools with the leverage of AI or Gen AI are able to do. So this sounds really good and promising, but let's take a look at the legal considerations that need to be kept in mind on the next slide. So from a Swiss law perspective, there are three main laws that come to mind when the recruiting process happens. The first one is the Swiss Code of Obligation, which regulates the employment relationship generally. And according to that particular regulation, an employer may only handle data concerning the employee if it concerns the employee's suitability for the job, let's say, for example, the skills, the qualification, and so forth. But also, and that's mainly relevant at the start, but also later on during the employment relationship, when it's for the performance of the employment contract. Let's say a work permit or marital status for tax purposes and social security purposes. Now, the General Data Protection Act applies, of course, as well. And there are several principles to comply with. And one which we can pick out is purpose-related processing, which is overread in that sense with the Swiss Code of Obligations. You have a duty to inform that basically always is there. And you also have a principle of appropriateness. And that's especially when you're a recruiter or when you're recruiting, that all comes down to the need to know principle. So within an organization, not everybody needs to know everything. And it's rather just to be kept towards the people that really need to know about this. So often information is given in the sense of privacy notices when it comes to recruiting processes. Nowadays, many of them are online or digital, or even with the tool. And often you click or you submit your application, and you sort of confirmation is your application is being submitted and your data is being allowed to be processed. Now, something special in Switzerland is the Gender Equality Act, which protects individuals from gender-based discrimination. And actually, this also applies during the recruiting process, as well as also the overarching guideline from the Swiss Code of Obligations. So not only during the employment relationship, but also beforehand. In case it should happen that somebody is rejected based on gender grounds, that can lead to a penalty of up to 3 monthly salaries of the potential hypothetical salary in the end. One thing to take along there is that the burden of proof is not eased, which might be the case for other discrimination claims during the employment relationship. So a potential candidate or potential employee will need to prove that with due detail that the discrimination happened based on gender. Now let's look at maybe some automated decision forms and how they're regulated in Swiss law. So we've talked about AI, and AI will more and more be able to, or maybe considers itself able to, make a decision. And now what happens if such tools are used which actively make a decision, maybe even on their own? Let's look into it. So the Swiss Data Protection Act regulates, firstly, different kind of information duties when it comes to the use of such automated recruiting decision tools. So in order for them to apply these information duties, there are twofold things. Firstly, a decision needs to be taken exclusively on the basis of automated processing, which very well could be AI tools. And secondly, the decision needs to have a legal effect on the individual. For example, in our case, the hiring or conclusion of a contract. Thereby, it's characteristic that the human involvement is not present with that decision. And the tool rather has a certain degree of discretion in making that decision. If we go back to the use case of robo-hiring, as I call it now, this could indeed be a case which falls here under if AI tools are used and they principally make a decision who to hire based on, for example, job description, applications received, and of course the data the AI tool or AI feature has been trained with or programmed with. If you use such tools which make such a decision, then the information you need to provide to the individuals are the modalities of the automated individual decision that involve logic, scope, and consequences. As an individual, you can request to file your own position against that decision in that sense, and also demand that the human reviews that decision. And one exemption, a big exemption, is consent. If an individual provides their consent, then this information duty does not apply. But this is often a pitfall in practice, as many people think if you just simply tick a box and say, I consent, that it's duly given. That's not always the case, because in order to duly consent, you need full information, you need a complete information, and it needs to be accurate. And often many people don't have the full facts or don't have the full and accurate details to be able to consent duly. Let's move on to the next slide. So what is the difference between sort of profiling and this automatic decision? Well, profiling means any form of automated processing of personal data, consisting of the use of personal data to evaluate personal aspects relating to an individual. Mostly it's used to analyze or predict certain performances or behaviors. For example, economic situation, health, personal preferences, interests, and so forth. Profiling should serve as grouping people into different kind of categories or sectors. And organizations often use profiling to find something out about preferences, again, behavior, or make decision. So keep this in mind as overarching guiding principles when such tools are used. And now let's move on to the next slide for some practice use cases. So we picked out 4 use cases for you to go through today. And you see on the left side where an AI tool is used, which is in all cases except for one. And let's just quickly go through them. Let's say an HR manager uses Excel to filter candidates' information according to the years of experience and simply just hires the most experienced person. Is that generally permissible? You can say yes, because it's just simply a statistical action and it doesn't necessarily relate to personal data in that sense, which again would touch upon the suitability of the employee anyway. If we move on to the next example, let's say an AI tool is used in this recruiting tool, a candidate apply, manager uses the AI function to filter out applicants which don't hold a master's degree. And then based on that, the HR manager makes a decision and rejects them. So now you can say, well, AI played a role, but it didn't make an autonomous decision on its own. It was reviewed by a human, and also the human made the decision itself. So that's also something which would be permissible because it concerns the suitability of the employee if the qualifications call for it. Now in the next example, let's say a firm is searching for a bricklayer. Candidates apply via a recruiting tool. HR prompts an AI function beforehand and to select the most suitable candidate based on the job description. The recruiting tool, what does it do? Rejects all women and send automatic rejection email to them. Now, let's say that the firm has not informed the individual about the usage of this automated process, which would not be good, which would not be permissible. They should have done that. And even the HR manager handling this case could be fined for that. And more importantly here, because a gender discrimination is quite likely, the individuals could even file suit for discrimination compensation up to 3 monthly salaries of the predicted salary. Now, even one thing which comes up in practice a lot is the last example, where a firm, in order to hire somebody, here a managing director of a high net worth individuals asset manager firm, looks around social media, the internet, and tries to see what kind of person is this. And they find something that they're part of a heavy metal band, and they post certain specific, let's say, pictures which might not fit in the picture of the asset manager, and then are rejected. Let's say in theory, this would generally not be permissible, although managing director might have a different kind of exposure in terms of reputation, if that might be the case. But generally, you're only allowed to process data which is relevant for the employee's suitability or then for the performance of the employment agreement. So likely, this would also not be permissible. Now, let's see what's permissible or not when we head into termination situations. Let's move on to the next topic, which is terminations during sicknesses, blocking periods. In the next slide, we have a quick overview on blocking periods in Switzerland. So when do they apply? Well, after probation period, if any has been agreed, there are certain statutory grounds that can be invoked, like, for example, sickness, pregnancy, military service, but they're also limited in time, so not forever. The most invoked ground in practice is sicknesses, and that's linked to service years. So in the first service year, you have a 30 days blocking period. In the second, 2 and including 5th year of service, 90 days, and the 6th beyond, you have 180 days. But what do blocking periods trigger? Well, during those, employers cannot terminate validly, except for cause which would be for immediate effect if the grounds therefore are met. If an employer has already issued a termination towards an employee, then these blocking periods would kick in when they would fall ill. And that means that the blocking period would actually interrupt the notice period and therefore prolong the notice period accordingly. We'll get to that in a second. Just keep in mind that this calculation of this blocking period, this kind of the protected period, is done backwards from the actual, meaning initial termination date. In practice, this means, and this is for many people from abroad, quite a big surprise, that in termination situations, if you are a company and letting someone go in Switzerland and close to the end of the employment relationship where the notice period is about to run out, the employee falls ill, let's say just for 4 or 5 days. And that 4 or 5 days prolongs essentially the employment relationship by at least those 4 or 5 days. And in Switzerland, the rule is like that the prolongation takes place until the next possible end date, which often in Switzerland is the end of the month. So by only falling ill for like 4 or 5 days in these situations, generally a full month's salary and full month employment can occur. Let's look at certain pitfalls on the next slides. During sicknesses, it's always a question of, is this accurate or not? So the burden of proof generally lies with the employees, and often in practice, it's a doctor's note. So employees provide a doctor's note to the company. But many Swiss employers exempt their employees from bringing doctor's note, at least for the first mostly 3 days, because they trust them and say, okay, if you're once ill, we don't want a doctor's note every time, and we will exempt you from that. Essentially, what happens then in these 3 days where you're exempt, this reverses the burden of proof. So let's say somebody takes advantage of it as an employee and falls sick and actually is not sick at all, then it's on the company to prove that the employee was able to work, which can be quite difficult in practice. And also when you're drafting employment documentation or employment handbooks, this is a careful consideration. How much trust do you give to your employees? How much control do you want? Certain companies, they want full control. Certain are quite liberal with the trust. And certain find kind of a middle ground where they say, as long as you're in an unterminated employment relationship, you have these 3 days of trust rule. But as soon as it's terminated, we want a doctor's note from the first day unless we spare you from it. And in case of considerable doubt, you can, as a company, fight those doctor's note if you believe that you have credible circumstances that it's not accurate, but it's quite difficult. So certain indicators could be backdated certificates, no physical examination, and also maybe somebody issuing a doctor's note, which this cannot be that in this kind of field that the person is operating. Luckily, the employers are not fully on their own when it comes to sicknesses. Firstly, there's a statutory obligation to provide sick pay, which again, by case law, is linked to the years of services, depending on where you're working and which scales applies, which is 100%. But also many Swiss employers nowadays have a so-called daily sick pay allowance insurance, which provides sick pay allowances in case of sicknesses. And those can be quite lengthy, up to about 720 days per case, although there's a waiting period of 30 days where there's no allowances paid. And often the benefits are capped at 80% of the insured salary, which at times is even capped on an annual basis. And we'll get to this in a second, where there's a sickness as well. The insurances also like to have eye on it. And we'll get to this on the next slide, which I can happily refer to right now. Can we move on there? Excellent. Doctors of confidence. If you want to challenge somebody's sickness, then essentially you have two options. One is you simply accept it. One and the other is you battle it out. And one form of battling it out is you send somebody to a doctor of confidence. And what that means in Switzerland essentially is that you just get a second medical opinion by a practitioner. You have the right to do so in Switzerland to verify the doctor's note. And the doctor of confidence, especially the second practitioner, is tasked with examining the employee's ability to work. Costs are borne by the employer, but the good thing is, from an employer perspective, that the employee must show up to that appointment based on the duty of loyalty, if the request is reasonable. So not some doctor which is 3 hours away from home or something, but if the request is reasonable. And as a company, you can say that we will stop paying any sick pay if you don't show up and you don't comply. The same thing can be done by a daily sick pay allowance insurance as well, which is often the case, especially in termination situations. At times they come to know, and if they have credible circumstances which they believe to be accurate, that the sickness is not true, then they might rather quickly send somebody to their doctor of confidence and maybe even freeze the allowances. Now, there's been quite an important case, case law by a federal Supreme Court, which we'll just touch upon in a minute, and which has underlined the concept of workplace-related inability to work. So sometimes the inability to work based on sickness does not actually mean that you fully are unable to work. At times, still, many tasks can be performed, some tasks cannot be performed, and also sickness can rather be ancillary, so that finding, for example, another job is not impacted by such sicknesses. And this is actually the whole purpose of all these blocking periods. The blocking period, if you're terminated, shall ensure that your sickness, because it reaches a certain degree of severity, prevents you from working, but not only from working, but also from finding another job. So if you're sick, then it's presumed that during these blocking periods, you could also not take another job. But sometimes also these sicknesses are not that severe. And the consequences of the blocking period, especially if it comes to prolongation, could be quite large. And in certain cases, in mental cases, in mental sicknesses, due to the happenings at the workplace, often these kind of sicknesses are related to the workplace itself or the company, or for example, certain people. So people would be able to work elsewhere after maybe recovering or simply switching jobs. And new case law states that workplace-related sicknesses don't trigger blocking periods. So at the moment, there's quite some uncertainty in that regard, what that actually means. And many employment lawyers, when they are in disputes against each other, you will see that they argued now that not only is the employee not ill, but they're also just workplace related, these kind of sicknesses. But let's jump into some examples on the next slide, please. So quick case study here. So now you see there's an employee, let's say there's an employee in the 3rd year of service. So for the blocking period, we would be talking about 60 days. This is in a 2 months notice period by the end of the month. And let's say the employer terminates the employment relationship mid of March, and then the employee falls sick. And now you might recall that that's kind of a special thing in Switzerland. The blocking period is reversed from the back, meaning that the end of the employment contract is looked at, and then the protected period, which you can see here in light blue, applies. So now with this particular scenario, we see that the illness does not trigger a blocking period because it's outside of that. But let's move on to the next case. Now we see here same circumstances again. The sickness occurs in the middle or close towards the end of the employment relationship, which would have been the end of May. Now, assuming that the sickness is valid, just these 4 or 5 days of sickness can prolong or will prolong the employment relationship to the next possible end date, which is here as per the contract, as the notice period runs out per the end of a month, end of June. So in this case, the new end date with also salary payment obligation is the end of June. Let's move on to the final case, which is workplace-related sickness. Let's again assume it's the example number 2, but then the employee falls ill because of a depression allegedly caused by a coworker's behavior, and it's heavily related to the coworker's behavior. You notice as soon as the person is not around that person, then this illness is not around. I know it's very hypothetical, but let's play it out. In that particular case, you would say, based on this new case law, that this could be a workplace-related sickness, and therefore the blocking period would not apply. So whenever you have certain cases like this, always ask yourself, is a blocking period triggered, and is it a workplace-related sickness or not, and what is the process we need to follow from an employee perspective, but also from an employer perspective. And with that, I'm happy to hand over to Adrian for termination and establishment of benefits.
Thank you, Gaurav. And after this, I would say quite complex topic. I will delve as a last one into a somewhat leaner topic, basically about the granting and terminating of benefits and you know how this needs to be looked at in case an employer wants to change any of that. And the reason we're looking into that is that we feel that benefits have again become a little more important in practice than they've been for quite some time. So we see an increasing number of clients approaching us with respect to the change or also kind of abolishment of certain benefits they currently have in place with their employees. And also we see, obviously, with the Gen Z having a lot of expectations towards employers in various regards that, benefits have again become quite an interesting tool to be an attractive employer. And also, it is a pretty dynamic, or I can say moving target. So these benefits, they might change because they're not sexy anymore in a year's time, or they become too costly, or maybe they're not ESG enough anymore. So there is also reason to change benefits every now and then, which probably brought some move into that topic. And please move on one slide. And let's see on how, in practice, you can agree or actually introduce benefits to staff. I mean, first and foremost, and that's the most common approach, obviously, is by written contractual agreement. So that could be included in any kind of, official document that is part of the employment contract. So including policies, any kind of side agreements that could even be done by email, where you get to such an agreement. And then obviously you can also verbally agree on whatever you want, including benefits, but that is not recommended, as stating the obvious, hard to prove for both parties, but still happening every now and then. And the employee would still want to claim it then going forward, even if it was agreed only orally. And then that is what you see, or we do see a lot in practice, is that employers just simply decide to introduce benefits. So they just by providing them kind of unilaterally, roll it out. And the question is then in a second step, and I'll get to that, what that means in terms of a claim of the employee. Just some example benefits that we see trending. There's actually nothing really fancy among it, to be honest, but besides a number of cash allowances, we see like well-being and health benefits in trend. You see some here listed like discounted gym memberships or health check costs, and also sometimes insurance, health insurance upgrades, which though are pretty expensive and well, mostly seen in the FS industry rather than in other industries. And then it's life management, if I may call them like that, benefits like dry cleaning, childcare and stuff like that. And maybe a little more fancy one is pet care benefits that we see trending, in particularly in the French-speaking part of Switzerland these days. But now let's move on to the next slide and see what these different ways of agreeing on a benefit may mean to permanent and or temporary benefits. We have added 2 examples there here on the top of the slide, which I'm not going to read down. But of course, if you have a benefit promised in a contractual agreement to an employee, coming with a clause saying the employee is entitled to, shall be granted, shall receive, or the like, obviously that results in a contractual claim. In a verbal contractual situation, that's actually no different, but again, hard to prove. And then looking at the third example, when unilaterally an employer kind of introduces such a benefit or a new benefit, or even changes an existing benefit, also kind of an agreement starts existing, because when the employee accepts it, which is typically the case with benefits, it's kind of a tacit agreement. But the question is to what extent this then raises a claim or actually justifies a claim of an employee if an employer decides not to go on with this benefit anymore. And we'll get to that in the next slide. As an overall remark, and that is actually also a recommendation, with all these ways of granting a benefit, if you tie it to a voluntary reservation, what we call a Freiwilligkeitsvorbehalt in German language, then you don't have a lot of issues when you do it right and word it diligently. If an employee claims the continued payment of, or how to say, receipt of benefits in a circumstances where an employer decides to stop them, then you just simply don't have an enforceable contractual claim. Please move one slide on, and then we get to what that means in termination circumstances. Of course, if there is a contractual agreed benefit, it's legally binding, so actually it can't be just simply stopped or changed by an employer by unilateral amendment, so it would rather have to be done then by termination with altered conditions, or what we call an Änderungskündigung in German language, respectively then within a mutual agreement with the employee. So even if like you change one benefit for another one, and these cannot be compared in value or nature, you have to be careful that you can't do that just like that. Or at least you may face some pushback from the employees. With those benefits that an employer unilaterally introduced, the situation is a bit different. You can't kind of claim that continuously as an employee if you just got it once, but there we look at similar consideration, as you might know, when it comes to variable salary components. So when such benefits have been repeatedly made available to employees over a couple of years, you may run into a situation where that gets like a contractually binding claim of the employee, which then would lead to the same situation as in a contractually agreed benefit. And then again, special case voluntary reservation. If you have a voluntary reservation, basically you don't have an issue as an employee if you want to terminate a benefit, but you have to make sure the voluntary reservation in nature is really unambiguous and explicit. Otherwise, it's a bit hard to prove, and there will be, if ever brought to court or at least to a lawyer, there will be factors coming into play, like, have they been provided regularly without a reservation over a couple of weeks or months or whatever then the right frequency is. And the question will also be whether the employee could justifiably, from the behavior of the employer, have expected to be continuously benefiting from those benefits. So that brings me actually to the use case, which is demonstrating exactly this voluntary reservation. So you might be surprised seeing such an old case because it dates back to 2011, but that's actually due to the fact that there is only little case law on this topic, which nevertheless doesn't make it not relevant. But that case played in 2011, where actually a retiree from his former employer received pensions through the period of 2011 to 2014, and then from 2015 onwards, the employer stopped to pay what they call the cost of living adjustment allowance. In German, we call it a Teuerungszulage. And obviously, the employee brought that, or the retiree brought that case to court, and but then actually the court, and we'll see that on the next slide, decided to protect the employer, because the employer, and that's what you can see here in blue letters, explicitly stated in his letter dated 2011 that the employer shall decide annually and without prejudice to the future on the adjustment of pension payments to inflation. And for 2011, the employer has decided to increase pension payments by 0.5% as of 1 January 2011. We would like to point out that this is a voluntary benefit and that no claims can be derived from it for the future. So this is really clear, but nevertheless, the employee brought the case to court because he thought maybe because he's been paid that also for 2012, 13, and 14, he could derive a legal claim. But then, and that's now the final slide, as I said before, the Swiss Federal Supreme Court decided not to protect the employee's claim. Can you move on one slide, please? Because this voluntary reservation was really absolutely clearly, unambiguously stated, because it mentioned without prejudice, no claims can be derived from it for the future. So, the employer won this case. It would have probably lost it if the counterexample that you can see on this slide of a clause would have been included in that letter from 2011 that says the retiree is entitled to receive an annual cost of living allowance in addition to his pension provision, calculated in accordance with the Swiss Consumer Price Index and adjusted each January. So that would clearly indicate that there is a continued right to receive such an adjustment payment. And so you really have to be careful whenever you make benefits available of whatever kind to your employees, that you tie a voluntary reservation similar to the one that you can see or could see actually on the previous slide to that in writing, ideally, to make sure you stay agile and can also apply changes or even terminate benefits when you want. And with that, we're actually coming to the end of the official presentation and have some time left for Q&A. So I'll probably hand back to Dan.
Thank you very much, Adrian. And just before we move on to the Q&A, I'd like to say thank you very much to Gaurav and Adrian for your presentations today. Incredibly insightful and a very important topic. So thank you very much for that. There is still time to get your questions in, so please do, if you have a question, please send it over to us and we will have time to ask that question. So I've had a question in here, Gaurav. So what about an employee continuously falling sick during the notice period? So for example, they come back and within a few days, a new sickness starts. Does the blocking period start afresh? Is there any limitation on the total extension of notice period due to blocking periods?
Thank you, Dan, and very great question. Indeed, very important. So generally, that's true that if, let's say, again, an employer terminates and you're an employee and you fall ill during the notice period, which is that kind of protected period, then it's actually like that new sicknesses would trigger a new blocking period. So let's say, for example, somebody falls ill for a long bit, let's say 90 days, but someone has only been with the firm for a couple of months and hence has only 30 days of like protection, then another new sickness or new ground would invoke a new 30-day blocking period. The issue in practice is, as a company, often you receive a doctor's note which just says you're full-time unable to work. You don't really know what's behind it. It's also not allowed to being shared without the consent of the individual by the doctor. So you often get a certificate which says, well, I'm not able to work for a certain period of time. And then what has been deemed the case is that when it comes to such new sicknesses, in first instance, it's generally deemed the same sickness in that sense, but then I wouldn't call it a burden of proof, but the employee is more on the call in that sense to prove that this is a new sickness in the end, because they're kind of deferring rights from that kind of sickness, and when it would go to court, they would need to show that it would be a new sickness in that sense. And this could be ongoing for a while, let's put it that way, but I've rarely seen that in practice. In that case, typically it's one sickness or maybe two smaller ones. Otherwise, it's a long-term sickness which mostly relates to the same root cause in that sense. Yeah.
Excellent. Thank you very much, Gaurav. We've had another question in your experience, in which cases do the labour authorities become aware of EOR and potentially staff leasing setups?
Yes, I can happily also take that one at the moment. So from our experience, the labour law authorities, as Adrian mentioned before, often become aware when, let's say, from the Swiss outbound kind of perspective, where you as a Swiss company, you hire or you engage an EOR and you hire somebody locally somewhere abroad, and that person for, let's say, training purposes or, for example, for work purposes comes to the ultimate factual employer into Switzerland, and then has to maybe get a work visa, work permit, and maybe those authorities, they look at, where is this person hired? Why are they coming to Switzerland? And they often forward such kind of applications or requests to the labor authorities. And then you at times get a letter as well. And sometimes you need to comment, is the staff leasing or not? What are you doing? But also, very generally speaking, when you are active in the market, the louder you scream as a provider, let's put it that way, the more maybe the authorities get to know what you're doing. And also if they have reason to believe or get a notification by a third party, by a former, let's say, employer or something like that, those are just the general grounds which could lead to such investigation or cases where they become aware of.
Yeah. Hey, thanks for jumping in, Gaurav. I was on mute. Rookie mistake. Sorry for that. Just quickly on the like ordinary setup that we spoke about in the beginning. When the EOR is located in Switzerland, you may indeed ask the question, when should this ever pop up? Because you then don't have foreigners coming into Switzerland that could challenge or could be challenged then in the immigration process on the potential existence of a staff leasing constellation. But where it happens there, or it may happen, and we actually seen cases, and we've even seen clients being fined, and I don't want to play here like the fear factor that consultants normally do, but it really happens, is when an employer of records gets scrutinied by the Social Security authorities in a ordinary social security review or in sort of an internal audit. If they happen to do that internally, and it's a large multinational EOR, they might even spot that themselves, and we've even seen an EOR disclosing that voluntarily to an authority to make sure they get their grace and can operate smoothly going forward without running into any disadvantageous situations. So, but yeah, it can pop up. I mean, staff leasing is not a major concern. If licenses are around, for sure, everything is good. If not, again, you just need to make sure that you don't shout too loud in the market, as Gaurav said, but you can't control that yourself, because the EOR is actually the one that can trigger it more than you as the client. So you depend on the EOR, its compliance, and that's why, again, we say you should get confirmations on compliance in all relevant jurisdictions from EORs, and also look into a hold harmless clause in case they fail to keep that promise up.
Perfect. Great. Thank you for that, Adrian, and thank you, Gaurav. If we just move to the next slide quickly, I think that we have Gaurav and Adrian's contact information on that slide. Brilliant. So if you do have a question, you can get in touch, Adrian and Gaurav, and we will send over their contact information once the webinar is finished. Gaurav, I'm aware, and Adrian, I'm aware that we're very close to the end. We have just had a question come in, which I think may take a little bit of time to answer. I don't know if you've seen it just in the feed at the minute. If you want to take that question now, we can do, or you can get in touch afterwards. If not, we are at 5 o'clock now, so completely up to you whether we've got time to take that question now, or we want to finish this after.
I mean, we're happy we're happy to revert to the participant who asked the question. If you can share that with us, and then we can take this up separately. And also, if you'd like us to, we can quickly summarize the response in the follow-up email with the deck that you're going to circulate with the participants, so that everyone can go back to work now.
Perfect. We can do that. And yes, unfortunately, right at the hour mark now. So thank you so much, Adrian, to Gaurav, for your time today. Your insights were greatly appreciated by myself, by our audience as well. So fantastic to spend an hour with you today. We hope we can have you back again soon. And thank you also to our audience for the questions that you've sent in as well, for participating in today's webinar. I hope everyone has a lovely rest of your day, and goodbye.